Hello, good evening, and welcome to the Bangalore International Center. BIC, established in 2005, is an inclusive and neutral platform for informed conversation, exchange of ideas, arts, and culture. Today's program is Interrogating the Constitution, the annual Vijay Nambisan Lecture 2025, presented by the Vijay Nambisan Trust. Poet Vijay Nambisan was known as much for his writing as he was for his reclusiveness. After his time at IIT Madras, he pursued his love for the written word and won the first All India British Council Poetry Prize in 1988. He worked for a number of years in the literary section of The Hindu and published collections of poetry and prose in his inimitable style. He was married to surgeon and novelist Kaveri Nambisan. The Vijay Nambisan Trust was formed to perpetuate the cause of humanities in its many spheres, and the memorial lecture held every year is the first event to be sponsored by the Trust in partnership with the Bangalore International Center. In today's lecture, constitutional lawyer and scholar Gautam Bhatia will examine the Constitution not just as a legal document, but as a dynamic terrain where visions of authority clash, intersect, and contend for supremacy. The lecture will be followed by a Q&A with the audience, so please hold on to your questions until then. To briefly introduce the speaker, Gautam Bhatia is a constitutional lawyer and scholar whose work bridges rigorous legal analysis and imaginative inquiry. He has argued in landmark cases, including challenges to the abrogation of Article 370, the electoral bonds case, and the right to privacy case. He is the author of The Transformative Constitution 2019, Unsealed Covers 2023, and The Indian Constitution, A Conversation with Power 2025. Beyond law, Gautam writes science fiction, exploring society, governance, and human possibility with the same depth and creativity he brings to the courtroom. Before we begin, I'd like to request the audience to switch their mobile phones off or put it on silent for the duration of the event. Please take a moment to do so now. I'd now like to invite the speaker, Gautam Bhatia, on to begin the session.
Thank you. Thank you so much for inviting me. I should begin by saying that I've just come from Delhi. This is around the time when the AQI goes up and our throats go down. So apologies for interspersing this with a few coughs or throat clearances from time to time. This is just an occupational hazard. I should also say that lawyers are very territorial people. And so in case someone later on watches the video and takes it amiss, I should just clarify that I wish I had argued in those cases, but I was just one of the many lawyers who was involved in those cases. But with that, thank you so much for inviting me to speak. Now, the topic of this lecture, Interrogating the Constitution, might raise a few eyebrows because there may be a lot of things you'd want to interrogate in our present day society, present day polity. But you might wonder why the Constitution is one of the things that requires interrogation, or what specifically about the Constitution requires interrogation. And where I come from on this is that I engage with the Constitution in three distinct ways. One is as a practicing lawyer who works with the Constitution and sees it being worked through in the courtrooms on a fairly frequent and regular basis. The second is as a constitutional scholar and a writer who writes about the Constitution, who utilizes constitutional scholarship to advance what I would like to think are broadly emancipatory goals. And the third is as just a citizen who observes the way that the Constitution plays a part in our daily conversations, our daily life. And the impetus for interrogating the Constitution really springs from what I often see as a gap between these three different ways of engaging with the Constitution. To give you an example, 5 years ago, you would remember the CAA protests that swept the country. And one of the important points or the grammar of those protests involved the reciting of the preamble and of Article 14 of the Constitution, which guarantees to all equality before law and the equal protection of laws. Now, these readings of the preamble were very inspiring. I myself was witness to many of them, and I myself was asked to do some master classes on Article 14 for activists and students. And what struck me was the gap between the popular imagination of what something like Article 14 promised, and what you would get in the courtroom, which is where the only authoritative, and by that I mean backed by state power, coercive state power, constitutional meaning is crafted. That is not to say that other kinds of constitutional meaning are less important, but that is the one that then is backed up by state power, right? And ask any constitutional lawyer, and they will tell you that Article 14 is perhaps amongst the weakest of the constitutional rights because it is the one where the court always accords the most deference to the state. So if you were relying upon Article 14 to make a constitutional argument in court, you would be quite hard pressed to prevail in that case. You would need other things to succeed in that case, including challenges like the CAA challenge. So they seem to be, and I see the same as well when I read the Constitution as a scholar who is trying to advance certain readings versus then seeing what kinds of readings of the Constitution really are accepted in the courtroom, what kinds of readings are considered to be off the wall, unacceptable. Again, that gap emerges. Now, one answer to that, and this is a fairly popular answer, is that the Indian Constitution is this great document. It's a document that is a charter of liberation, of emancipation. And the problem has been that over the years, it has been twisted to nefarious purposes by unscrupulous politicians, and there's a history of that from Nehru amending the constitution every time a judgment he did not like was passed, to Indira Gandhi suspending the constitution, to various forms of constitutional skullduggery that are going on right now. So the document is great, but it is twisted and distorted by nefarious politicians, and then that twisting or distortion is then provided a seal of approval to by a court that is either unwilling or unable to confront the executive. And again, this is a historical story. It goes back to the first 20 years of the court and then onwards. So there is this common argument that the goal is to defend the Constitution from the vicissitudes of political oppression and attempt to strengthen the courts so that they can withstand political force. And if we were to succeed in these goals, then we would be in a better position. That is an argument that I often hear. But what I have found during my time in practice with the Constitution and seeing it work and work itself through in the courts is that this sometimes seems to be a somewhat perhaps simplistic story. And I'll explain what I'm saying by giving two short examples of recent, uh, very politically significant cases, and then going a little deeper into one case I was deeply involved in, which was the abrogation of Article 370, and what that proceeding in the court tells us not just about the court and about our politics, but also about the Constitution as a document and the imperatives that it really, brings out or brings forward. The two smaller examples, well, the first one is the recent presidential reference on the issue of can governors basically exercise pocket vetoes over legislative bills. So in all these states, primarily opposition, like only opposition rule states, you have a situation where the assembly will pass a bill, the governor will just not act on it because under the constitutional scheme, the governor's formal assent is required to make that bill a law. And this will go on for years and years. So effectively, the elected assembly of the state is unable to pass laws because the centrally appointed governor is basically exercising a pocket veto by just not signing and not referring them to the president. That's another option that is there before them. Now, a few months ago, the Supreme Court in a two-judge bench, as many of you would know, said that this really is a fundamental subversion of the constitutional scheme. and the court said that henceforth there has to be a 3-month time limit in normal circumstances. There can be emergencies where you can extend that, but the governor and the president have to act within that time frame. And if they don't, then they will be deemed assent to those bills. So it will be as if they had been assented to. Now, of course, then there was an immediate backlash, and the Supreme Court, and this is not the subject of this talk, but in a highly regular procedure, effectively reheard that case in a combination of 5 judges using the presidential reference route, and that's presently awaiting an opinion from the court. Now, what I want to really focus on is that the Supreme Court, in its two-judge combination, really had to stretch the limits of its authority to come to its conclusion, which was that there is a 3-month time limit on what the president and the governor can do, and then they'll be deemed assent. The reason is that at no point in the Constitution does it say that there is a 3-month time limit. The Constitution does not actually impose any kind of limit upon the governor or the president's powers of action. The reason for that is that when our constitutional framers were framing the Constitution, they were still very much engaging with the old Government of India Act. At this point of time, states were still the old provinces. They were perceived more as administrative, units, not the states we know now with their own linguistic, often their own ethnic, often their own cultural identities. But they were perceived to be the old colonial administrative units. And the governor was perceived to be the centers, well, at that time, mostly only man, and now, of course, both men and women, in those units who could then exercise the center's prerogative when required. And so, therefore, the constitutional framers basically left these gaps in the Constitution where they did not actually, even though the governor is not answerable to the people of the states, there is this discretion that is left in constitutional silences, which can be abused if the governor so chooses. And so it depends entirely upon the governor's own conduct or their own sense of their role and their position. And so, therefore, if you are a neutral observer, if you come to this judgment perhaps unaware of the context in which India is, if you were to analyze this purely as a legal artifact, this judgment, you would think the court has perhaps overreached. And even if not, even if you knew all the context, what is clearly happening here, and this is my view, is that the court is trying to solve through judicial interpretation effectively a constitutional design problem. And that is unsustainable in the long term. You can't solve through decree what is a problem with structure and design of the constitutional document. Another similar case is the election commissioners. Again, a very, very prominent ongoing issue. We've seen multiple challenges to the impartiality of election commissioners. And this goes back to, again, a Supreme Court judgment of 2023, where the court said that the prevailing method of appointing election commissioners was unconstitutional, and the method to be used would be the Prime Minister, the opposition leader, and the Chief Justice, a committee of three, who would appoint the election commissioners. And the court said that this would be an interim arrangement subject to Parliament passing a law. The law Parliament then passed was one that effectively legislated executive dominance into the process by saying that the committee of three would be the Prime Minister, a Prime Minister's nominee from the cabinet, and the opposition leader. So effectively, the executive appoints the election commission. As you can see, this is where a player in the game appoints a referee. It's completely absurd. But if you look at the Indian Constitution, what the text of the Constitution says is that the appointment of the election commissioners will be conducted in a manner that Parliament lays down by law. And until the time that Parliament lays it down by law, the president will have the power to appoint election commissioners. And that was the process throughout history. And so, therefore, the Indian Constitution itself, actually, from its inception, envisaged a situation where effectively the executive would be the appointing body for election commissioners. No doubt in the belief that those who were actually running the executive would not be partisan in this nature, but clearly a belief that over the years has been proven to be somewhat optimistic. Um, and this is really at variance from most modern constitutions, where bodies like commissions either are appointed by a non-partisan body, which means you keep the politicians completely out of it. It's an apolitical technocratic body, or a multi-partisan body where you have representation from both the ruling party and the opposition to ensure that the referee is someone who has the competence of both sets of players or multiple players in the electoral game. But the Indian Constitution's text itself did not envisage that. Now, the Supreme Court in 2023 says that, look, if you look at the debates in the Constituent Assembly, you will find that they really intended that the election commissioners must be independent of the executive, obviously, otherwise it doesn't make sense. And they thought that Parliament would, in due course, pass a law guaranteeing that independence. Parliament has, over the last 70 years, failed to do that. And therefore, until Parliament does that, we, the court, will have this interim arrangement. Now, the subtext of that opinion, therefore, is that when Parliament does pass a law, that law should secure the independence of the election commissioners. But of course, that's not explicitly there in the Constitution. And so, therefore, when the Parliament did pass this law, which sanctified executive dominance over the election process, when this was challenged as effectively violating the Constitution and the Supreme Court judgment, a fresh Supreme Court bench with different judges was able to say, look, where in the Constitution does it say that it has to be, independent? We'll hear the case later. We'll see. And they refused to pass any kind of orders. This was before the last general election. And now we have multiple state elections with an election commission that is actually under some serious cloud. And so again, what you come back to is you come back to gaps and silences in the constitutional text. You come back to this struggle between competing interpretations of those gaps and those silences. But the problem in both the presidential reference case and in the election commissioner's case is that if you were to look at the Constitution's text and ask yourself, where does this document guarantee the independence of election commissioners? Where does this document guarantee that governors cannot exercise pocket vetoes over elected legislatures? The answer is it does not. This has to come from some kind of design based reading that says, okay, an overarching principle of the Constitution is parliamentary democracy. That would be completely subverted if governors could exercise pocket vetoes. Therefore, we will read into the Constitution the requirement of 3 months. But that is a much more difficult argument to make than just saying, look, there's nothing in the text, so where are we getting any of this from? Which is, of course, the argument that the state makes. So, what, therefore, I want to really say with these examples is that when you think of the Constitution, when you think of constitutions in general, you often think of a document that one of whose primary goals is to constrain state power. It's to provide checks and limits and balances upon state power. It's a document that will seek to protect the individual from the vagaries of state power. That's quite an American view of looking at things. It's the view popularly ascribed to the U.S. Constitution, and because of the dominance of the U.S. Constitution, global constitutional thought, it is often taken to be the goal of constitutions in general. And so we often, in fact, even talk about the Indian Constitution as one that is a bulwark against, executive tyranny, a bulwark against political oppression, and so on. But that is actually the assumption that I think merits some kind of scrutiny, as these examples show. And actually, historical research does demonstrate that the primary motivations that often drove the constitutional framers, or at least some of the major players in the Constituent Assembly, so Ambedkar, Nehru, Patel, Alladi, Krishnaswamy Iyer, and so on, was actually the idea of the Constitution primary goal not being to check or to constrain power, but to facilitate or enable its exercise through the mechanism or the vehicle of a very powerful centralized state. They all came at this from different angles. So for Nehru, the dominant motive or motivation was the economic problems India was facing, as well as the need to speak with a unified voice in the international domain, the idea of the developmentalist state. And so, if you look at his speeches, you will see that concern being really prominent in needing to have a strong centralized state. For Patel, it was the issue of law and order, of integrating the various Indian states, and so on. And for Ambedkar, it was the idea that given the kind of entrenched caste structures that operate at the local level, only a strong central state, which is appropriately distant from and impartial between these power structures, will be able to mediate and actually protect the rights of oppressed people and Dalits, because state governments can be taken over more easily by these kinds of caste structures. So they all had different motivations, but they all converged on thinking of the Constitution as a document that would really enable the exercise of power and would do that through the vehicle of a strong and centralized state. Now, of course, theirs weren't the only views in the assembly. So you had other counteracting views in favor of federalism, in favor of a more decentralized structure. One of the most eloquent voices when it came to the Sikh schedule areas, Adivasi areas, was Jaipal Munda, who regularly spoke about the need for autonomy out of and against the sort of centralizing state. He was often shouted down and, in fact, really heckled in the assembly, but he made his point. And of course, you see influences of that then coming into the constitution. So what you have finally then is a constitution that is a terrain of competing and often contesting visions of power. So it's not that this is a uniformly and rigidly centralizing and centralized constitution. That's not the case. It is one where you have these competing visions of power that come into contest. But the point I want to make is that often, in terms of the constitution's final text, which of course has the imprint of these three and some of their other close colleagues, as well as the constitution's design, often the dominant impulse is a centralizing one. And I call this the centralizing drift. And what then you see in history is that at various points after the constitution comes into being, the Indian Supreme Court is faced with a choice. It is faced with deciding a question for the first time, about some part of the constitution. And at that point of time, there are two paths open to it. One is the path of affirming a more centralizing reading of the constitution, and the other is the path of affirming a more decentralizing or less centralized version of the constitution. And I argue that if you look at the Supreme Court's record over the years, barring a few exceptions, it is almost uniformly a centralizing tendency that always wins the day. So whenever you have a judgment that is really one that decides which way we will go in terms of federalism, institutions like the Election Commission, other kinds of bodies, asymmetric federalism, pluralism, and so on, the vision that the court subscribes to is one of centralizing. And it doesn't say it explicitly so, sometimes it does, but that is really what the underlying current is of these judgments. And here is where, in my view, the text, the history, and the interpretation sort of reinforce each other. So I'm not saying that this is a court acting in bad faith or a court that is just captured with the executive. Sometimes in history it has been. So I'm not saying it's always independent. But there is almost a kind of what I call a constitutional common sense that in the halls of the court, there is just this assumption that when in doubt, centralize. When in doubt, when there's a silence, a gap, always pick the more centralizing reading. And we can go into examples in detail later on. But I think so for me, to illustrate the way this works, I'll talk about this case, the Kashmir case, because it's a case that I worked on for many years and had the occasion to engage with in some depth over a long time, and then was a ringside spectator to how the hearings went down, and of course the final judgment that then came down. So as all of you know, Article 370, of course, was part of the original constitution, and it came about basically. And if you look at the history, it came about not because the Indian constitutional framers wanted to extend autonomy to Jammu and Kashmir, but because they had no choice. The only way to ensure that Jammu and Kashmir remained formally a part of the Indian Union was to grant to it special status or autonomy under Article 370. So what they did was then that they crafted this very complicated and very confusing article, very multiple clauses, subclauses, and just in brief, what they said through this article was that there is the Indian Constitution and there is a Jammu and Kashmir Constitution, which is being drafted by the Jammu and Kashmir Constituent Assembly. So you have these two constitutions. Now, what this article says is that if you want to extend any part of the Indian Constitution, excluding issues around defense, communications, and that's a whole different story. So, excluding those things, if you want to extend any part of the Indian Constitution to Jammu and Kashmir, you will need the consent of the government of Jammu and Kashmir. Back then it was the Rashtra now it's the government. So effectively, you have what you can call a principle of double consent. That this is a relationship where both the Indian Union acting through its representatives and the government of Jammu and Kashmir, both parties have to consent to the extension of the Indian Constitution to Jammu and Kashmir. And if you want to make any alteration to 370 itself, which sets out the terms of what's happening here, you need a recommendation from the Jammu and Kashmir Constituent Assembly, which the president will then ratify of India. So that's the method of changing the very nature of the relationship itself. Now, I really simplified this. The article had many more moving parts, and I don't want to go into that because that will take us far afield. But in a sense, that was what the arrangement was meant to be. Now, one question that arose soon after the constitution's framing was that the Jammu and Kashmir Constituent Assembly drafted constitution for Jammu and Kashmir, and then it dissolved without really making any recommendation for the removal of 370 or any alteration to it. So the first question that came about was that look, now Jammu and Kashmir has a constitution and which governs the state. And by the way, just to clarify, the idea of states having constitutions is a very, very familiar idea in federal theory. So the US, right? All the US states have their constitutions. So federalism is very, very familiar with the idea of there being two constitutions, union and state constitution. That's not at all something that's out of the blue in federal theory. So one question that arose was that now the Constituent Assembly has basically done its work, and there is a constitution. Does 370 still have any role to play? So can the President of India still keep extending the Indian Constitution to Jammu and Kashmir, piece by piece, bit by bit, once there already is a Jammu and Kashmir Constitution? The reason why this became important was because after Nehru had imprisoned Sheikh Abdullah, there was effectively no real opposition to the center from within the state of Jammu and Kashmir politically. So basically, all the extensions the President of India made were just assented to by the Jammu and Kashmir government. Now, that would actually have been prevented had the Supreme Court held that once there was a Jammu and Kashmir constitution, there would then be no more extension of the Indian constitution to Jammu and Kashmir. I would have entrenched the autonomy of Jammu and Kashmir in the constitution. The Supreme Court, on the other hand, said that no, that's not the case. In fact, this is a continuing provision, 370. And the president can basically keep extending the provisions of the constitution piecemeal to Jammu and Kashmir. So, what the court then did through that was that it replaced what was meant to be the constitutional entrenchment of autonomy for Jammu and Kashmir and replaced that with basically a reading of the constitution that would make Jammu and Kashmir's autonomy dependent on the balance of political power between the two forces. So as long as Jammu and Kashmir's governments remained subservient to the center, there would be no objections to the continued extension of the Indian constitution to Jammu and Kashmir. So over the years, then, piece by piece, bit by bit, the Indian constitution was extended to Jammu and Kashmir. Interestingly, the parts that weren't were, ones, for example, that would actually have protected rights. So, for instance, in Jammu and Kashmir, for the first 15 years after independence, you could not challenge detention without trial at all. This was a special rule for Jammu and Kashmir. But that's a different story altogether. So, over the years, effectively, 370 became a shell. Effectively, bit by bit, piece by piece, the entirety of the Indian Constitution was extended there. I explain this because it's background to what finally happened and to understand what happened in the case. Now, in the case itself, the 370 case, which flows from the events around August 5th, 2019, when through two presidential orders, effectively 370 was removed. There was some long and complex process that the Union of India did, which again, we don't really need to go into because it's not finally relevant for the case. But there is this long, complicated process via different constitutional article. Like they did some interpretive shenanigans and they removed 370. And this was challenged as being unconstitutional. Now, interestingly, during the hearings, it appeared that pretty much everyone realized that what they had done was indefensible. Under no constitutional theory can you remove 370 in that way, in the way in which they did. So then they actually came up with a new theory, which was that the proviso to Article 370, Clause 3, which is basically what I mentioned earlier, which is that if there has to be a change to Article 370 itself, then that can only come about from a recommendation of the Constitutional Assembly of Jammu and Kashmir, which the president has to then ratify. They said that, look, this assembly has now ceased to exist. It ended in 1956. There's been no assembly since then. Therefore, that part of the clause is now otiose, is redundant, and effectively the president can unilaterally remove 370. So this was such a crazy theory that even they hadn't done that themselves when they were doing it in what they actually did. But that's what they claim. They say that actually for the last 75 years, everyone got this article wrong. Nobody really understood it. Actually, all of this time since it began, there was always the possibility of the Indian president, the executive, unilaterally removing this article altogether. Which, if you think of it, is quite a claim to make. That it's the constitutional provision, it is the entire architecture of a state of the union, and you're saying that without any consultation with the state, the executive of the center can just remove all of that with one decree, effectively. And the court actually accepts that view in its judgment. And to do that, it has to first of all ignore the constitutional text, which says that there's a precondition, which is the recommendation of the assembly. But what's more relevant for our conversation today is the reasoning that the court actually gives. And the reasoning, or what you can make of the reasoning of the court, is that the idea was always that eventually there would be integration between the state of Jammu and Kashmir and the Union of India. And so any step that is taken towards achieving that goal of integration is broadly okay. The court will accept a step that is taken in service of that goal. But then the deeper question that you have to ask is, what does the word integration mean? And if you ask that question, what clearly appears in the court's judgment is that when the court uses the word integration, it is referring to homogeneity. So the idea that every state in the Indian Union must have the same relationship with the center. So even in a country as diverse as India in terms of religion, language, ethnicity, all of that, there must be uniformity in the political arrangements that connect the two levels of government. And again, that is not something that is at all a part of federal theory, because in many, many countries all over the world, there is a recognition that if your country is diverse in this sense of language, politics, ethnicity, and so on, your federalism will reflect that. So, Canada, Quebec, that's an example. Many others, Belgium, Flanders, right, and so on. So, it is not unknown to federal theory. But for the Indian Supreme Court, that was completely unacceptable. The idea that as a normative principle, as as actual constitutional value, you could have different states enjoying different kinds of relationships with the center based on their historical, political, linguistic circumstances was just not something that was acceptable. That was one thing. The second thing was that a question arose before the court that what is the relationship between the Jammu and Kashmir constitution and the Indian constitution? And here, what really, and this is not so much you will feel in the judgment, but this is more in the oral arguments. The court was completely unwilling to accept any kind of argument or even hear an argument that would have said that there is a complementary relationship, or any argument that would say that the Indian constitution is not superior to the JNK constitution. So for the court, that the only way of understanding this relationship was of a hierarchy. And again, in federalism, there is nothing says that has to be the case. Nothing says that in a federal polity there can be a complementary relationship between the center and the state constitution. There is no requirement of there being a hierarchy. This was something that the court simply assumed or just insisted had to be the case without any real reasoning as to why that had to be the case. But underlying the court's view, therefore, was the idea that ultimately this is a constitution that is meant to homogenize, it's meant to centralize. It is suspicious of difference in this way. It is skeptical of entrenching differences in political terms, and this vision of integration is not one where heterogeneous polities integrate by respecting that difference, but one that's meant to really flatten those differences. And this is not surprising because, and actually, Rohit Day and Ornit Shani, in a very recent book called Assembling India's Constitution, which I would recommend to everyone, they make this point that when the Constitution was being framed, any kind of concessions that were taken from the framers of the Constitution with respect to devolving this kind of power to Kashmir or to the Sikh schedule or to the northeastern states, which were then not states, were really very grudgingly given. So only when their hand was forced that the framers really agreed to give some kind of devolution, and for a long time they resisted in certain cases. So states like Nagaland only come into being much later because finally you have to give a state to curtail an armed insurgency. But what that shows is that there was never really this kind of moral or ethical idea that the Indian constitution should reflect the diversity of the Indian, people or the Indian polity by having these arrangements in place where the diversity is then reflected in the constitutional scheme. But the imperative was towards centralizing and homogenizing. And that then plays out in the way that arguments are made in court 60 years later, where the court just does not countenance that there could even be a scenario where the JNK constitution has a status complementary and not inferior to the Indian constitution. In fact, suggesting it invited accusations of being anti-national. Right? That's that kind of thing. That's the level at which the arguments were conducted in the court. So therefore, I take this example because I think it really reveals two things. One, of course, is that the Constitution is this terrain of competing visions of power. So in this case, of course, those of us who were on the side of challenging the abrogation, we did advance this vision of power, which was a more decentralized, a more asymmetric, a more pluralistic vision, and it's possible to read the Constitution in that way. But it is very challenging because one, Constitution's text and its history are resistant to that reading, and secondly, the court over the years has entrenched that resistance by judgments. So you have this combination of centralizing text and centralizing judgments that over the years make it very difficult then to really challenge the centralizing drift of the Indian Constitution. Which is why we now have situations like the election commissioner's case, reference case, where it almost seems like the court is struggling against the Constitution's text to try and fashion some kind of progressive ruling. And the moment that judge goes, it's very easy to roll it back, because the text allows that rollback to happen, with judges who are less keen to really argue against the Constitution's centralizing drift. So what that then leads us to, therefore, I think, is to interrogate the Constitution, to ask ourselves that evidently the Constitution's framers had good faith reasons to want a strongly centralizing constitution in 1947 to 49. There were clearly reasons. They are transparent about their reasons. They're not obfuscating the reasons. They're not hiding anything. It's out there, and scholarship has investigated that. But a constitution is meant to really endure for generations, right? And so, if they were responding to the situation before them, and in that process, they locked in a set of designs and structures that today still commit us to a centralizing project in a very different context. I think then the question arises that, do we need to interrogate not just our courts and our politicians in how they wield the Constitution, but also to interrogate the Constitution itself, and to ask, what kind of arrangements actually would fit, if our goals are emancipatory, non-authoritarian, non-centralizing. Then, like, how do we engage with the Constitution that we have in today's day and age? So that is the question I would like to leave everyone with, and I will close on that note. And I would welcome a discussion and Q&A. And thank you once again for inviting me to speak here. Thank you.
Yeah, thank you so much for your lecture. My question is particularly in the context of the application of Article 370. Like you discussed some very interesting themes about the thoughts of the makers of the Constitution. For example, Dr. Ambedkar's idea of ensuring justice in a society like India's. Now, with respect to Article 370, there were also these concerns about the rights of certain communities being denied, certain rights protections not being extended, right? And also there are these other aspects of it being an historically a frontier region, the politics, the international politics around it. So when we think of interrogating the Constitution as a very idealist document in these academic discussions, but somewhere we also need to fill that gap, to take into account, let's say that the rights of these people are met, or certain concerns of the Indian state are taken into account. In that case, how do you think, are the courts justified to make the kind of judgments that they are making, in a very realistic sense, and in order to kind of address these concerns for future, do you think, let's say in France, like we say the French is currently the Fifth Republic, do you think that the Indian Constitution needs a new avatar of some kind, and would it be a good precedent to set?
Well, I mean, look, we can go back and forth on this whole issue of 35A, which is, again, I mean, there's a long debate over there, and violence and the frontier reasons, all of that. But that is, again, that's not really something that is relevant for a court, because if that is the reason the court starts to decide judgments, then there's no point in having a court, because then you just accept what the union government is saying, right? So the moment the union government says that security issue, if you then stop adjudicating, then there's no point in having a court or a constitution, because then you just have a executive sort of like rule, right? The question here was that, is it constitutionally permissible for the president of India, the executive, to act unilaterally? Does the constitutional scheme allow that? That was the question, and that's a purely constitutional question. It's not relevant there. The border status, all of that, that's just not a consideration, because if there was, then there should be something in the constitution that says that, right? If the constitution says, look, border states are exempted from the constitution, right, then fine. If you have an emergency, fine, right? But in the absence of that, these are not arguments that a court actually should be taking into account, because, like I said, then there's no real point in having a court in the first place. Now, on the Fifth and Sixth Republic bit, So my view is that actually, I mean, I don't think there's a new republic in place. I think that actually, in a very deep sense, many of the power structures in place that the Indian Constitution has are quite holdovers from the old Government of India Act. Now, I shouldn't be mistaken here, because there is a very common argument that, look, you borrowed these provisions, you took them. So there is a whole debate about the old act. But I think actually, if you look at the way that the colonial 35 Act envisioned the way that the executive would function in sort of this borderline presidential fashion, and the way that the constitution then set up the executive, you see many similarities and continuities. So I think actually it's more a continuation of the vision of power in the colonial documents than any new republic that has now come into being. So I think we're still in that old republic actually, that is quite old now, and we haven't yet reimagined the way that power might work in the new sort of constitutional dispensation.
So my question is about the centralizing tendency that you just alluded to. As a next step in the centralizing tendency, if the present central government or any future central government try to take away the powers of the states to legislate and instead just reduce them to administrative units, would there be support in the Constitution for that? In my opinion, this is a very real prospect. So there's a reason I'm asking the question. I would like your opinion on that.
I think that's like a very interesting question, and that really goes to, I think, the heart of this conversation, because obviously now the constitution's formal structure, right, is a federal structure, and you have these three lists: the union list, the state list, and the concurrent list. And the union list is the fields under which the union can legislate. The state list is the state legislation, and then the concurrent list is the both can legislate, but the union law will prevail over the state law. Now, it is difficult to envisage a situation where, you know, a majoritarian parliament will remove the lists, or will just like eradicate them. I don't see that happening. But what we do see, and this is where it comes in, right? What we do see is, for example, governors not signing bills. Now, if a governor does not sign a bill for 3 years, which I think was the case in the Tamil Nadu judgment, which gave rise to this reference, you have effectively stopped states from legislating, right? So you have used constitutional silences, you have used gaps in the constitution, and the thing with, and this is a really important thing to remember, is that whenever a document has a silence or a gap, that silence will favor the stronger party, right? So it'll always favor the stronger party if you have like an absence of clarity, because who can take advantage of vagueness? Somebody who has the power to do so. Now, if the constitution says that the governor has to formally sign the law for it to become a law, then that's where the power is. And so the constitution may have never thought of a situation where the governor would hold on to a bill for no reason for 3 years, but it didn't say so in the text. And so that vagueness and that silence then is a ground for effectively accomplishing indirectly what you can't do directly, which is that you can't directly take away states' powers, but you can do it by just effectively bringing legislation to a standstill by just not signing a bill. I think that is the issue, and over the years there have been many such instances. So again, to give you an example, now many of the entries in the lists overlap. So industries of certain kinds are in both lists and so on, and a lot of like what we have seen is that the union keeps, and this is independent of whoever is in power, they keep trying to expand the interpretation of these lists entries that they have power to legislate under. So they keep getting more and more power, and then they cut down on the state's powers, because if there is a clash between two laws, union law prevails. So if there is more scope for union law to operate, more clashes, more prevailing of union law, which really makes it very important for the court to really guard, the boundaries of these fields. The court has done so in tax cases, but not in the rest of the cases. So in tax cases, they've been very strict. They have said that unless you, the union, show us very categorically that where is the power in this tax entry to tax this thing, you don't have it. Otherwise, they've been very generous with expanding the power. So it's a bit of a patchy history there on lawmaking.
I'd like to ask you about a point Ambedkar made in 1948 when he
Yes.
said that a constitution by itself is insufficient to protect us, and we need a culture of constitutional morality.
Yeah.
And that culture will have to be inculcated because the Indian soil is essentially undemocratic. So, we haven't achieved much on that count. And where could that culture spring from? Because in a country with low development indices, where the undemocratic soil carries all these barriers of caste and patriarchy, etc., the challenges civil society faces are so immense that it's going to be difficult to do this. So, where's the hope in that?
Yeah, I mean, I think it's really interesting you make that point, because there is also Ambedkar also says at the end that we have the constitution. It now depends on the people who run it, right? So a good constitution can be wrecked by bad people and vice versa. And I used to be very impressed by both that line and this line, and but I've become a little more skeptical about that, and I in fact quote that in the last part of my book when I conclude. I think that Ambedkar, in both of these quotes, he underplays what institutions can do in terms of achieving this. And I think that what happened was that, again, for various reasons that they no doubt thought were powerful reasons, the framers created a very top-heavy constitution where they really focused power in the executive, and in that way, the whole project of democratizing power more, like across society in various levels, was not really done in the constitution. And the institutions that were set up were really, as I've talked about, they were designed to keep vesting more and more power in the center. And the thing is, once you start down that path, once someone has power, they're not going to give it up, right? So the more power the center gets, the less they'll give it up. And so over the years, what we've seen, therefore, is that barring certain moments like post-emergency, there's been this sort of flow of power both to the center, but also from parliament to the executive. It's not just state center, but even within the center, parliament has progressively lost power, and the figure of the prime minister has gained it over the years. And so I think that you have to democratize the institutions, as a precondition towards democratizing people more generally. Because if people don't have the option to exercise democracy in these myriad ways, in the myriad channels, but we have this whole patrimonial system of like a top-down executive whom you almost vote for by acclamation every 5 years, then you really can't have a democratic culture, right? Because then the sort of the it's a reversal of the relationship between the constituents and the people in power. So I think, like, at least in part, it's about the kinds of institutions that the constitution sets up and what incentives that those institutions have for where power goes and where democracy goes.
Namaste. I'm Anusha from Chanakya University. I'm an assistant professor of law. I have few observations, and before that, very beautiful lecture. Thank you, Gautam ji. Here, one of the two judges inclining towards centralization is fine, but the whole bunch of judges from the Supreme Court are centralized, means they are towards centralism, concentration of powers in the center, and there is no federalism. Means, does that mean that the Supreme Court is in the clutches of central government and there is no judicial independence? That is one observation. And then the other one is the concept of secularism, how it is there in the Western state, it's not there in the same in India. So the concept of federalism also has its Indian version. It need not be same as it is there in Western. Here, Akhand Bharat, the concept of Akhand Bharat, I'm not favoring any centralization or concentration of powers in the central government, but then it's just an observation that in a family, there is a head of the family, and then though the other individuals have their own power or they have their own potential, but still they fall in line with the head of the family. Why? Because there should be some organization, everything should go. if the center is not strong, then there is possibility of being attacked by the external forces. It's just an observation, and I want you to throw on this lines. Thank you.
Well, I mean, I don't think I'll comment on your last 2 points because I don't think that's really the purpose of discussion today. But on your first point, so in constitutional, writing, there is this idea of what they call a constitutional culture, or what I call constitutional common sense, which is that there exists a set of assumptions and beliefs about what the Constitution requires that are widely shared by people internal to the practice, so lawyers, judges, writers, and so on, and to an extent the public as well. And so one doesn't need to be captured by the executive, one doesn't need to be formally captured. It is just that there is a common way of thinking across both the executive and the court over the years as an entity, that this is what the Constitution requires of us as constitutional actors. Now, again, that is not something that requires an actual capture or like influence or blackmail or threats or whatever, although, of course, in our history we've had that. But you don't need that. There is often just a consensus that this is how we understand the Constitution. And as I had explained during my talk, one way it really manifested in the 370 case was on the relationship between the two constitutions. So in that way, it is basically almost an unspoken sort of assumptions about what kinds of constitutional arguments can be made and what can't be made. And there's something that really you can't really actually isolate in terms of explicit terms. It's something it's part of the culture of like constitutionalism. Just understand it by being in the practice or being internal to constitutional practice. And so you won't find it written down in like a judgment or like, I mean, at times you will. So I'll give you an example. Actually, one case I often teach is from an early part of the Supreme Court's history, first 20 years, on interstate trade and commerce, involving tariffs that the states put up between each other for transport of goods. And in that judgment, while adjudicating upon the tariffs, the Supreme Court says that one of the goals of the Constitution is a unified national market. Now, that is nowhere in the Constitution. It's basically something like the EU, like a common market within India. It's not in the Constitution at all. You won't find it anywhere in the text. But there is a belief that the court and the government share, which is that the Constitution is a developmentalist document, and you can't have development without having a single common market. So in that way, much of this is just unspoken assumptions that really manifest in the course of practice. And it's not that somebody's influencing somebody else. It's how they proceed over time.
Yeah. My question is, how do you agree with the proposal that all these guarantor institutions, say something like an election commission or NHRC or an information commission, instead of the way they are, to make it the fourth organ of the government? Like, say, only way I can ensure that they're free and independent is making them the fourth wing, like say judiciary, executive, legislature, and these institutions. Right now, I just see them as the mouthpieces of the executive. So is that a right way to go about it to fix this issue, or are there other mechanisms used by other countries to ensure the independence and the free functioning nature of these institutions?
Yeah, most modern constitutions now have a separate chapter for what you call fourth branch. They're called integrity institutions in South Africa. They're called democracy institutions in Kenya. And in all these places, basically, the idea is that, again, like I said, for the election commission, you either have a non-partisan appointment process or a multi-partisan appointment process. So you either take political actors out of the equation, have a technocratic appointment process, or have one where you balance out the forces so that they can't be slanting one way. Now, the exact design is something that is really up for debate. But obviously, the problem in the Indian Constitution is that it's all executive controlled. So it's basically solely executive prerogative. And in fact, interestingly, like the only body that is outside the control of the executive formally in appointment terms is the judiciary, which only came about because they completely inverted constitutional meaning to take that power for themselves. But in the Constitution, even the Supreme Court, the appointment actually is by the executive. It's worth remembering that. And even that had to sort of be yanked out in 1992. But otherwise, no, I mean, the Indian Constitution doesn't recognize the idea of a fourth branch at all. So that is the problem. And we see it in the Information Commission, issues where they keep amending the law, taking away those powers all the time. So, yeah.
Yeah. So considering that centralizing tendency that you were talking about is very reflective of the cultural hegemony in this country and the populist imagination of being an Indian.
Yeah.
And when we, I don't know, challenge those prevailing notions, we very quickly get branded anti-Indian and anti-national. Do you think we actually have the space to interrogate the Constitution, considering it has its own reverence sort of in our society, especially in the judiciary?
Yeah.
So do we have the space to interrogate the Constitution?
Yeah, I think there's always space, and in moments of history, there's been more space than other times. So, one interesting moment when there was that space was 1977, when Indira Gandhi lost the election after the emergency, and then there was this wholesale overhaul of the Constitution, and there were these very serious proposals to really rethink the Constitution's centralizing characteristics. And I talk about that as a missed moment in my book, because of various reasons that we can talk about. But I think what that shows is that this is not set in stone. None of this; these are all human artifacts, and there may not be a possibility to see some of those visions right now enacted into sort of law as such. But the thing is, you never know when that moment will come. And so that's why it's important to have those conversations at all times, even when it feels like it is against the grain and there is no real prospect because the consensus is against that. It is only by having the discussion at that moment when it is the hardest is when the moment arrives to rethink. Then there is a corpus of thought. Right? So that's why I think it's important to not stop the conversation. It may never happen, but I think the objective is to make sure that if the centralizing vision is something that you are not convinced by, to always think of and talk about what the other visions may look like, so that there's always that conversation alive at all times. And yeah, I mean, again, there are various points in history. I talk about this in the 1920s, for example. A lot of the princely states had very radical experiments in constitutionalism, recalls, referendums, all kinds of other kinds of imagination. And then during independence, there were others who had their own constitutions. In Rohit Day and Audit Shani's book, they talk about this Manipuri draft constitution. So there's always been a trend of thought. It's not hegemonic. So it's always been there. It's never died.
I'll just have a quick question on, you mentioned the US as a federalist constitution and it's sort of dominant. Do you have any counterweight constitutions that are much more non-federalist? I know the Indian one is obvious, but any others, and if they've been successful?
There's a whole spectrum across the board, right? So, for example, in Kenya, a country I know quite well in terms of its constitution, they have something called the devolved counties. So it's like one level in between full federalism and a unitary state, right? So they have the devolved counties. The UK, right? So it's unitary, it's not federal, but they have like a Scots parliament, and they have some kind of Welsh like parliament. But again, it's sort of the overarching supremacy is Whitehall and Westminster. So yeah, it's the whole spectrum from unitary to like devolved to federal to confederation. This one. Belgium is even more federalized. Switzerland, confederation of cantons. So this is a whole spectrum, and it depends upon each country, like how they do it and what they do. Interestingly, for a long time, Nehru was proposing what he called the Scotland solution for the Northeast for the first 10 years, where he thought that best way is to have a Scotland-type situation for the northeastern states. Didn't come to anything finally, but yeah, so there have been these kinds of proposals also in India in history across time as well.
Yeah, I just wanted to know that people say often that secularism and right to religion, those kind of things came in later and not originally part of the constitution, and also things like socialism. So, when was right to religion and secularism actually included in the preamble and in the constitution?
Right to religion is there in the Article 25, which is part of the original constitution. Right to practice, profess, propagate a religion. And then you have the whole set of provisions 25, 26. 26 is denominations, 27 is taxes, and then 29 is minority rights. So that whole thing is there in the constitution. The word secular was added in 1970 during Indira Gandhi's emergency. But secular is anyway too vague a word to really have any purchase. The actual bite is in the text of the constitution. So those provisions are all there in the original constitution.
Just one quick question. There seems to be a lot of tension between the North India and South India.
Yeah.
Staying in South India, we see it. And how does the Constitution, have to take care of it? Because it's a cultural thing. Recently, I read somewhere that the difference in culture is because of family structure.
Yeah.
The North Indian family structure, it's a very fascinating thesis. So how does that play out?
I mean, I don't have the expertise to comment on, I think, those differences. It does play out, I think, in certain ways in terms of political power. Because if delimitation happens on the basis of population, then the southern states, of course, have less representation in the center. And now there is a big controversy brewing about the next delimitation, because right now you've frozen the seats on the basis of 71. And if you were to now do delimitation on present day population, you would basically, really downgrade the political representation of the southern states, which will cause problems. Now, there are two solutions given. One is that effectively, depart even more from the one person, one vote principle and just, keep the seat arrangements frozen in place. I think that's not really right or fair because, there's like one person, one vote should be the governing principle of any democratic constitution that has electoralism as its founding principle. Now, you can disagree with that, but that's a different disagreement altogether. The other is to strengthen federalism. So actually, because right now, again, because of the whole skew towards the center, representation in the center matters so much that it will cause all kinds of problems. But if you were to rebalance power between center and states, then it wouldn't matter all that much, so I think that's the much more fair and just solution is to rebalance the power than to say, okay, we will effectively freeze the constituencies and therefore really depart from the one person, one vote principle. And of course, the third thing is then to do delimitation and then really decrease the political power of certain states. And that's, I think, going to be very problematic if it happens. But that's all up in the air. We'll see how that goes. Culture, I don't know. I mean, apart from just anecdotal observations about interacting with people across the country, but nothing more than that.
Thanks, Gautam. So, appointee, which is the governor, and there's a huge push for, at least in narrative, push for one nation, one election. So, what guardrails do we have in the constitutional text and general jurisprudence to kind of not happening in the near future? Because that will be the absolute doom for federalism and pluralism.
Well, you will have to amend the constitution to introduce one nation, one election. So you will have to have 2/3 majority in both houses to do that, and that's the guardrail because there's only a political safeguard. There's nothing more there. So yeah, I mean, yeah. No, what I'm saying is that you will need to have 2/3 in both houses to be able to pass this amendment, and that is the only safeguard. There is no other safeguard. It's a political safeguard because there is nothing in the idea of one election that is inherently anti-constitutional. So it has effects which are damaging and which are bad, but there is a distinction between bad effects and something being unconstitutional. And again, people will disagree over this. My view is that the only safeguard that we have is that you need to have 2/3 in both houses to really implement this. And right now, the present government is not anywhere close to having that. That may change in the future, but and if it does, then you know, yeah, yeah. But again, this kind of cuts both ways, right? Because once one party loses power, the same rules then favor the other one. So this sort of can really cut both ways. Yeah.
So just a question on this liberty, which is guaranteed by the Constitution and which the Supreme Court is supposed to be the custodian. But it's very alarming with the way these bail things are being handled nowadays. So right now it seems to be a very broken system. There's absolutely no consistency on who gets bail, who doesn't get bail. Why does bail cases have to go up to the Supreme Court in the first place? And someone who's rich can go, you can approach the court depending on your status, depending on your lawyer. So how do you get, I'm assuming you agree with me, and how do we get out of this mess? Because it's really at the heart of the liberty, the right to liberty.
Yeah, there's no quick fix or even a slow fix. I think that there has to be an overhaul generally in the legal culture. So one is that we have a tendency of over criminalizing in Indian law. So you see a problem, you criminalize it. And that's sort of our reaction to that. And the harsher you criminalize it, the more you think you've dealt with it. So one is that mindset has to really change. And the other is that, like you rightly said, there is no reason why bail is going to Supreme Court. In no other functioning country does this happen. It happens here because effectively the trial courts and the high courts think that, okay, if we don't give bail, let the Supreme Court handle the mess. So we'll refuse bail, let them handle the mess finally. And so it keeps going up. So that has to change. But again, this is a very, very long, very slow process that I don't even know how you do it, because the problems are so entrenched in terms of like what I said, that how do you convince magistrates across the country to look at, I'll give you an example. The Constitution says that within 24 hours or as soon as reasonably possible, you must be produced before a magistrate if you're arrested, right? And then the magistrate will decide to if your further custody is required or not. Now, the reason why this safeguard is there in the Constitution is because the idea is that within 24 hours, let a judicially trained mind look at the arrest and determine if there is a reason why you should be in custody any longer. And if you look at countries like Kenya, magistrates frequently will refuse remand. In India, it's a rubber stamp. So no magistrate will ever refuse remand the first time. So you will be in jail for a while or in custody for a while. And again, how do you change the mindset that even one day, in custody without reason is a really gross violation of your fundamental rights. How do you change that? I don't know. It's clearly like a very deep problem. So I think it's just a very long, very slow process. And how we do it is, you can write and you can speak about it and you can litigate all those things. But we've been doing that for years and without any screaming change. So I don't know how you do it in the future.
So just wanted your comment on the Delhi Government Services Bill. No, the last one, which gave the power back to the LG. So how does the legality of that sit with what's in the Constitution?
That's a challenging question to answer, because the 239AA4 of the Constitution, which is the provision that determines the relationship between the Lieutenant Governor of Delhi, the President, which is the executive, and the Assembly, is a very vaguely and ambiguously worded provision, because it authorizes the LG to disagree and then refer to the President, and a lot of the legislation stems from that provision. Now, the problem is that the Supreme Court in 2023, while striking down the notification that had transferred control of services, basically said that there is this triple chain of accountability, there are three nice words that were used. But basically the idea was that if the elected government cannot control the bureaucracy, then there is no way that you can hold the government accountable as the people. And so then effectively you're undermining parliamentary democracy. That's what the court said. Now, unfortunately, as the Supreme Court often does, it said this very nice thing. It started a notification, but when the Parliament reenacted the same thing in law, Supreme Court has not heard the case yet. So effectively, it's still undergoing. Now, if you ask me, I think it's obviously unconstitutional on the basis that if the Constitution of India is committed to parliamentary representation as a basic feature, then depriving any elected government of control of the bureaucracy is undermining that, and therefore it's unconstitutional. But nothing in the text again is there. So again, you're faced with the same problem where constitutional ambiguities and silences can be exploited by the more powerful party, in this case, the union government, and there is nothing you can do unless the court intervenes, and the court decides not to. So that's sort of a very, very common story that's been the case for many years now. And I should, of course, say that I was part of the case, so obviously I'm biased. But yeah, that's a caveat.
You had mentioned in the beginning that the courts are sometimes unable to take a decision because the Constitution does not really contain the provision. For instance, in the case of the governor's side, approving the bill and holding up the bills. Now, ours is a written constitution.
Yeah.
So no written document can
Yeah.
look into all exigencies. They cannot cover all the
Yeah.
exigencies.
Yeah.
What the courts have to think of is what is fair,
Yeah.
what is common sense,
Yeah.
and what it is that the Constitution really wanted
Yeah.
when it was framed. So in that case, I mean, it may not be a question of saying 3 months, the governor should not hold on to the bill for more than 3 months, 3 months, 2 months, 5 months. That's a matter of, but they cannot hold on to bills and subvert the legislature. So that kind of thing, surely the courts can take a decision.
Yeah, I mean, so this is the really challenging thing, right? So, like you said, the any written document is open textured. That's what we say in law. It's open textured, and so it'll never resolve all questions completely, and there'll always be silences and gaps. Now, the problem, of course, is how do you resolve those gaps? And so, for example, what the argument that was made by the state, by the Union of India in this governor case, was that the Constitution has left some questions to the political process. And this is something that is for negotiation between the assembly and the governor and the president. And this is not something that the court can resolve through a decree. Now, you may disagree with that reading, but it is a reading of the silences. And then, of course, the other side is saying that effectively you can't negotiate when like one party has all the power, right? So like the governor can just not sign it. So who's negotiating here when like one party literally has the power? And so that doesn't make any sense. But basically, the point is that the constitutional silence will always give you at least 2 readings. That's the point of a silence. It will give you at least 2 readings. And there, what happens is that, like I said, the constitutional culture that's sort of there in the courts of implicitly accepting that centralization is a good thing, often then leads to resolving or answering the silence towards a more centralizing reading. I think that's what happens. So I think that's the issue that then happens in these kinds of cases.
Yeah. Hi, Gautam. And you're here. So, looking at the 2 technology evolutions post constitution came into place. Looking, for example, I tried to look at how the electricity evolved and how it strengthened the evolution of electricity. Yeah, and it powered federalism a lot. Most of the states have electricity boards, but when you look at internet, it's powered federal more. So, what changed in this scenario, and how it became more a centralization force? And what lacked in this governance scenario?
Yeah, because because telecommunications have always been a central topic. So in history, and this is true generally for like all states, even the most federal states, federal countries will reserve defense, foreign affairs, and communications to center to have like uniformity across the country. So internet's part of telecommunications. That's why. Yeah. It does, yeah. But that's why the architecture is because of this reason. Because under the Indian Constitution, telecommunications is part of the union list. So that's why that's the reason why it's there. Of course, the harms are a lot, but that's why electricity is a state subject and internet is not.
Regarding the rebalancing of power between the states and the center, if there's a proposal on the table, I know there isn't, but if there's a proposal on the table to adopt a Senate on the American model, exactly 2 votes for each state, regardless of population, would the courts deem that to be in violation of the basic structure doctrine or not, in your opinion?
I don't think it's a violation of the basic structure doctrine because because my reading of all the judgments is that the basic feature is Republican democracy, and all of this is consistent with that. So actually, in my view, and I'm a little in the minority here, I think that even if I think it's a horrible idea, but if tomorrow there was to be a shift from the parliamentary system to a presidential system, I think even that is not a constitutional violation. Like I think it's a terrible idea. It would make things much worse. But if that is the amendment that happens, then I don't think there's a case to challenge that in court, because all the what it says is that there should be democracy, and all of this is consistent with that. So again, I think Senate's a terrible idea. I think like it's like really distorts the whole process of lawmaking, and we can see what happens in the US. Like it's just I mean, you look at that and you say, okay, we have issues in here, but at least we don't have a Senate because that just really compounds things so much. You don't want that sort of thing happening here. But yeah, I mean, to answer your question, if there was a proposal, I don't, as long as you maintain democratic form, any sort of like specific shape is constitutional. But this is, many people will disagree with me here. So many people will say that actually parliamentary democracy is the basic feature. So you can't shift from that. So that's like a contested view among like lawyers and legal scholars.
Excuse me, sir. It's regarding the constitutionality of this UCC,
Yes.
Uniform Civil
Yeah,
Code.
yeah,
Now, how do we perceive that? Like, are there any gaps, in the process of realizing it? How do we see that?
It has to be seen on a. This is what I always tell people, that UCC as a concept makes no sense because there can be hundred versions of a UCC, and so you have to look at what a specific law is saying, and is it meeting constitutional standards of equality, gender, justice, and so on. Many proposals have been put. Feminist movement has codes that they have proposed. I think it just have to look at what a proposal is and assess that. As a concept, I can't, either way, it doesn't really, it's too abstract as a concept to say good or bad. But what is the law actually saying? Then you ask, and then you say, okay, no, this is right or wrong.
I am Arvind here. The citadel never falls except from within itself.
I'm sorry, can you repeat that?
Citadel never fall, never fall except from within itself. So having said this, the vis-a-vis independence of a judiciary, judiciary is capable to put a time limits for president and governor in a Ravi's case. Is it failing to guard itself when its recommendations are not cleared from the government? I am saying it from the viewpoint of the Aditya Sondi taking his consent back. So the judiciary is failing to guard itself against the tyranny of the executive.
Yeah, I mean, the problem here is the opacity, right? So if this was all in the open and transparent, then you could see what's happening. Whereas here it still is all like basically corridor gossip. Oh, so and so was withheld. So and so like this, and that is destructive for any kind of democratic process and the court's own independence. So I think that what is basically right now happening is the worst of all worlds, because we have on the surface an independent process, on the surface in formal terms, but actually, no one knows what's happening. So either formalize it, right? Like, because in fact you would have probably heard that the transfer of Justice Sridharan from the Madhya Pradesh High Court to Chhattisgarh was then changed to Allahabad, and the original resolution of the collegium read that on the request, something on the request of the government, etc., etc. Now, what did the government say? Like, what was the request? Is now the government having inputs on this in this way? No one knows because you don't know what the request was. And in fact, there's no formal mechanism of like, if the government wants a person to be appointed or like, to be transferred, there's no formal mechanism for it making that request. So it's all like, informal. And then now that after backlash, they took down that collegium resolution. So clearly, even they know that something is off here, right? So I think that the problem is that you have a situation where there is clearly engagement between the executive and the collegium on appointments, but no one knows how it happens, and that is the real problem.
Regarding your point on constitutional common sense, what I would like to understand is how do we make it more common sense wise?
Yeah.
And if you look at from when we've had a constitution to today, where there's gradual use of central being the supreme power that's predominantly getting benefited, then how do we ensure that there's no abuse of this power? And extending that a little bit, how does someone like a common man like me, who's not a part of any larger organization or system, but I'm interested in where the constitution is going and how it's happening, and I want to subscribe to something called as constitutional common sense. So
Yeah.
how do I become more involved according to you?
Well, I mean, so on the issue of, I'll take your last question first. I think that, one problem is that many of the more modern constitutions really have a lot of provisions for citizen engagement in the processes of lawmaking, other kinds of admin action, and so on. So many of the Latin American constitutions specifically have a role for people to participate beyond elections. We don't have any of that. The proposals were made, but they were turned down because, again, there was this idea of like sort of really not devolving power to people outside of the organs of representation. I think there are ways such as, now you have obviously you have like pre-legislative sort of consultations that sometimes happen to make your views heard there, and to sort of engage just on a daily basis in your daily life with like constitutional issues. I think is pretty much what any of us can do. Some of us have access to legal vocabulary, so we can be in courts, but honestly, the most powerful constitutional meaning is shaped outside of the courts. And that sort of brings me to your first question, which is how do you change constitutional common sense to something more egalitarian? And again, what I've seen, it's only when there is a shift outside the halls of the court that things change in the court. So, for example, it was only because of the backlash to the Supreme Court's judgment in Kaushal on same-sex relations and the sustained movement that took place that then led to it being reversed within 5 years, which is unheard of. 5 years is no time at all for a reversal of this kind. Many of the gains in sexual assault and rape law that came as a result of the women's movement. So these are, the RTI as an act came as a result of the RTI movement. So I think this is how it happens. Like shifting of meaning outside of the court is then what will shift the meaning inside the court. Again, this is all very easy to say. It's very hard to do. So I'm not going to say that it's easy, but that's I think how we do it.